Good morning. My name is Ben Nolinsky. I'm the Senior Vice President for Structural Reform and Governance here at the Center for American Progress. I'm honored to welcome you here for a set of discussions on the Supreme Court and the future of American rule of law. Though we are still contending with significant fallout from the most recent term, we now must turn to the consequential cases that lie ahead this term, and also what we can do to make a push for reforms that are needed for the health of our republic. Anyone who has paid any attention to the Supreme Court in recent years has noticed a radical rightward lurch, gutting voting rights, ending Roe v. Wade, eliminating environmental protections, and declaring that American presidents are, in fact, above the law. But the big takeaway, really, is that the justices are willing to do almost anything to put their political program ahead of the law. Justice Thurgood Marshall could have been speaking today when he said, "Power, not reason, is the new currency of the court's decision-making." But I want to break this down a little for what it means for Americans. Last summer, the court blocked student debt relief that would have given tens of millions of Americans a brighter future and an ability to invest in theirs. Earlier this year, the court's extreme majority pulled the rug out from under public agencies trying to protect Americans from workplace abuses, polluting industries, financial fraudsters, and unsafe food and medicine. In their view, judges should be able to substitute their own political and ideological views for the views of Congress, who are elected by the people, and public agencies who are charged with protecting us. Within days, we saw cases brought in the courts that cited those decisions in seeking to block rules that had been put forward to protect Americans. Things like the Department of Labor's fiduciary rule to protect investors, like the Department of Health and Human Services rule to ensure non-discrimination in healthcare, and like the FTC's rule to ban non-compete agreements in labor contracts. And against legal precedents and overwhelming public will, the Supreme Court has taken away the national safeguard for a woman's right to an abortion, to fatal effects. Amber Thurman, Candy Miller, and so many more women have died or been irreparably injured because of state abortion bans that the Supreme Court let happen. All of these decisions occurred at the same time that right-wing billionaires and power brokers like Harlan Crow, the Koch network, Paul Singer, and Leonard Leo were ingratiating themselves and their causes before the court to Justices Clarence Thomas and Samuel Alito. Investigative journalists reported that Justices Thomas and Alito received hundreds of thousands of dollars in benefits, gifts, and travel from powerful right-wing interests with business before the court. It further came to light that Justice Thomas and Alito's spouses have flown the flag, literally and figuratively, for extreme political movements. All this while refusing to recuse themselves from cases to which they and their families were connected. And in doing so, they led the court to virtually anointing the president a monarch through the recent immunity decision. We have to ask ourselves, who do we entrust with this supreme power? How can we ensure a more balanced, ethical, and constitutionally minded branch? A more accountable branch to the people? This answer is simple. Congress can and must act to pass legislation establishing a binding, enforceable code of conduct and term limits for the court. No person should be above the law, and no public servant should be beyond accountability. That includes the Supreme Court, which leads us to why you are here today, the 2024 Supreme Court term and what it means to reform our eroding judicial system. Our first panel will look at upcoming cases in the 24 Supreme Court term and examine the threats they pose to the rule of law and for Americans' hard-fought rights. The second panel, moderated by CAP's Senior Director for Courts and Legal Policy, Devon Ombres, will address the need for both structural and procedural reforms to the Supreme Court and lower courts to shore up the foundations of our judiciary. Though this current state of affairs is discouraging, I am grateful to see so many of you here engaging with the issues and committed to a path forward. With that in mind, I would like to introduce our first panel, the preview of the 24 Supreme Court term. Our moderator is Mark Joseph Stern, senior writer at Slate magazine. We're so thrilled that he's here today for this conversation. And our four esteemed panelists are Lene Erickson, senior vice president for social policy, education, and politics at Third Way; Lisa Heinzerling, the Justice William J. Brennan Jr. Professor of Law at the Georgetown University Law Center; Jessica Marsden, director of impact programs and counsel for free and fair elections at Protect Democracy; and Kelly Sampson, director of racial justice and senior counsel at Brady. I want to especially give thanks to Court Accountability and Third Way for co-hosting today's event. We're really thrilled to do this in partnership with them, and want to thank you all for being here, and I invite the first panel to join us.
Thank you so much. Thank you, Ben, for that introduction. I warned our panelists beforehand that I usually start with the person immediately to my right, and I noticed that they all scurried over to the other side. And so I guess no one is super enthusiastic to talk about the Supreme Court's cases this term, which is completely rational because it's going to be another barnstormer or barn burner of a term, in the sense that they're probably going to burn down the barn again. Not sure how many more barns they have left to burn down at this point. But, we're here to talk about what's about to happen. And at the same time, I feel like it's always so important to root a coming term in the context of what happened last term, especially when you have a Supreme Court whose majority clearly has a list of items on their agenda that they are aggressively trying to tick off as quickly as possible. So I guess I'm actually going to scramble my formula here and start with Lisa, because who thought she was safe, but she's not, because Lisa is one of our foremost administrative law experts, and last term in so many ways was an admin law blowout. And so before we talk about some of the admin law cases arising now, could you just sort of remind us about the rubble of last term and what happened there?
Yeah, so as you may know, but we'll get all on the same page before we talk about the current term, the Supreme Court has been, I think it's not too strong to say, waging war on the administrative state. Two of the justices were actually put on the court in order to do that, selected for that very purpose. What that means is the court is really challenging the power of administrative agencies like the EPA, like the FDA, like the Occupational Safety and Health Administration. And it's doing this in a bunch of ways. And I'm going to talk about, in particular, about one area, which is agencies have long had the ability, recognized by the Supreme Court, to interpret the statutes they administer. And if a statute, and under this formulation, was ambiguous, was unclear on a particular point, then the courts were instructed by the Supreme Court to defer to the agency's reasonable interpretation of that statute. This was a position taken over many decades and kind of confirmed and crystallized in a case called Chevron, after which the deference was known as Chevron deference. And so the court has done a couple of things to that regime that have greatly disrupted the administrative state and portend future disruption. So one thing the court has done is it has engaged in or created some so-called clear statement principles for statutory interpretation. These are ideas where, in certain contexts, the court has required, just of its own accord, there's no law that requires this or allows this. The court has said, if you're going to do thus and such as an agency, you need to have clear statutory authority. Congress needs to speak super clearly. Now, notice the shift there from the agency to the courts. It is not only the agencies that are disempowered by these interpretive principles, but Congress as well. So that the court has said, you know what, if an agency is engaged in answering a question of great political and economic significance, Congress needs to speak super clearly. If an agency is having a significant effect on the government power over private property, Congress needs to speak super clearly. If an agency is disrupting the balance between federal and state power, Congress needs to speak super clearly. So these principles, which are only 2 years old at the most, about 2.5 years old, really limit agency power to take on big things. And you may notice a skew in it. The idea is that agencies are at risk under these theories when they try to take on big problems and in an ambitious way, right? The other thing the court has done is overturn that principle of deference that I talked about, and has replaced it with a rule that the best interpretation prevails. There's only one best interpretation of any given statutory interpretation, according to the Supreme Court, and that best interpretation is to be decided by the courts. And judges are not free to decide for an agency when they think they have a better interpretation of the court. This profoundly disrupts the current state of, or the recently passed state of affairs. And just to give you a sense of how important these principles are, one of the most certain ways to undo an agency's regulation is to say they had no legal authority. And that's what these interpretations go to, is whether agency had legal authority for what it did. And maybe I'll stop there by way of background. Do you want me to talk about
please.
the current
So
term?
let's see how that might play out in some of the cases that we're looking at now.
Yeah. So for me. Oh, yeah. So there are two environmental cases, which are the cases I'm particularly thinking about, although these concepts will play out also in a case about ghost guns, I expect, before the court this term. So in the environmental cases, the interesting thing to me, I don't want to necessarily get into the real technical details of these cases, but to sort of talk at a higher level, how I think these cases are consistent with this general pattern of attacks on administrative agencies. One case is a Clean Water Act case involving what EPA can require in permits under the Clean Water Act. And it has to do especially with whether the agency can require a source of water pollution to meet standards that states set for water quality. So how clean does the water have to be, basically, to use that water for what the state has designated it for? If it's for swimming, for example, recreation, then it has to be cleaner than for industrial uses. So the idea is, can you put that kind of limit, a limit on what the source can do in terms of the quality of the water?
And that's San Francisco versus EPA.
Exactly, exactly. The second case, and then I'll tie them together in a way, the second big environmental case that's already been on the docket for the term is a case called Seven County Infrastructure Coalition. And it involves the National Environmental Policy Act, which is a statute that requires environmental impact statements, kind of reports on the environmental consequences of agency actions that significantly affect the environment, right? So it requires reports. And a court had held that the report of the Surface Transportation Board, which dealt with the building of a new rail line, which would predominantly carry waxy crude oil in Utah. The building of that the permit process for that hadn't adequately described the environmental consequences. So the question is, did the court require too much in terms of the agencies describing the consequences? And both cases have a similar characteristic in the briefs, which I think follows directly from the kinds of cases I mentioned at the outset, which is they don't really talk about the statutes, right? And especially the Clean Water Act. They blow past the statute, which in my view is pretty clear, and I can make any statute ambiguous, right? It's pretty clear that it allows, indeed requires, the impacts on water quality to be embedded in permits, right? That's kind of the purpose of the Clean Water Act, let's just say, is to make the water cleaner. So it kind of makes sense to consider that in permits. And they just blow past the language and say, oh, but it's unfair, it doesn't give notice, it doesn't create regulatory certainty. It's an extraordinary set of briefs in that case that fly, I think, as quickly as possible away from the statute itself. And I think that's where we are with respect to these cases, where the Supreme Court has opened up such kind of amorphous ideas and allowed them to affect agencies' legal decisions, that's what this invites. It invites departure from the text, but departure from the purposes, and it flies to pro-industry policy points. Same thing in the NEPA case. In the NEPA case, I actually have a hard time even knowing exactly what the argument is. Either it is so clever that no one can understand it, and the Supreme Court can project whatever desires they have onto it, right? They can figure out, they can come to a result that's consistent with that argument in many different ways. So the argument is a little bit unclear, and it's in a case that the Supreme Court didn't really have to take. It's a sort of workaday NEPA case. It really didn't have to take it. The split in the lower courts, I think, is overblown in the briefs, but it really poses threats to this statute, the National Environmental Policy Act. The Supreme Court has long been not a fan of NEPA, but this case will allow it to speak broadly on exactly what kind of impacts are to be considered. When this comes to climate change, it's really important. A rail line that didn't exist before that can make crude waxy oil or waxy crude oil available, right, in great quantity, when what might not have been available before, has huge climate impacts. Can you consider those? Or do you just need to figure out how much environmental impact comes from, like, the railroad ties and things like that, right? And so they're both very big cases. I'll be happy to talk about more details, but I think the big message is they're really encouraging a kind of departure from ordinary statutory interpretation in favor of one that relies on policy arguments.
Yeah, thank you so much. You mentioned the ghost gun case, and I feel like that's a logical place to go next. Kelly, if you want to talk us through Garland versus Vanderstock, which is also partly administrative law case, but one that has, well, like so many, has literal life or death consequences.
Yeah, thank you for that. And I love what you said about part of what the Supreme Court is doing is curtailing agencies' capacity to deal with big problems. And when we talk about gun violence, obviously that's one of the biggest problems that we're facing today. It's the number one killer of children. And to contextualize these cases by basically curtailing the capacity of the government to deal with them, it's allowing for minority capture. Because ghost guns, if you're not familiar with them, are basically almost one step away from a firearm. So they are unfinished frames and receivers that you can buy, and it doesn't take much technical skill at all. In fact, one of my colleagues at the time that he was a senior in high school went through the exercise of putting one together just to show how easy it is. And that's important to know because according to the Supreme Court, these take some great technical skill. So this case arose because the Biden-Harris administration issued an executive order basically directing the ATF, which is the Bureau of Alcohol, Tobacco, Firearms, and Explosives, to classify ghost guns as firearms under the Gun Control Act, because the Gun Control Act, when it defines a firearm, also says that an unfinished frame or receiver that is readily capable of being created into a firearm is also a firearm. So the Biden-Harris administration issued this executive order basically saying that these ghost gun kits need to be treated as firearms. It wasn't even necessarily saying you can't have them. It was just saying they have to be serialized. You have to go through a background check to get them, basically bringing them out from the wild into the administrative rule. And the reason why it's important, I should have started with this, is because ghost guns are unserialized and before this executive order weren't subject to background checks. And if that sounds like it's a recipe for allowing people to get them who shouldn't have them, that's exactly what it is. And we've seen in recent years almost 1,000% increase in recoveries of ghost guns at crime scenes. Because people know, I can't pass a background check, but I can get a ghost gun, get a few simple tools and put it together. So they issued this executive order and they were sued. And at first, there were a whole host of procedural machinations, you could say. But ultimately, the Fifth Circuit attempted to say that during this lawsuit that this rule should be invalidated until the Supreme Court rules on it. And at first, last year, the Supreme Court, in a 5-4 decision, said that that was not the case, that until this rule is actually interpreted on the merits, that it could still stand. So as of today, the ghost guns rule is in effect, but there's a case coming up where the Supreme Court will actually consider whether or not there's real authority to regulate ghost guns, and that will determine whether or not this rule will continue to stand. And it's another example of the Supreme Court really getting involved in issues that it doesn't have the expertise to do so. The case hasn't happened yet, but we expect that what they will do, and we could talk about Cargill, is really insert themselves in a place that they shouldn't. Congress passed the Gun Control Act. Congress defined what a firearm is, and then the ATF is empowered to carry out Congress's stated intent. The Supreme Court is not the place that we need to go to decide what is and isn't a firearm when that's already been done. And so this case just shows sort of the extreme implications of empowering the Supreme Court rather than the agencies and Congress to regulate such a really, really big problem for us.
So you mentioned that the Supreme Court allowed this rule to take effect, and by a 5-4 order, which is chillingly close, but still, the rule is in effect now. I know that the number of ghost guns recovered at crime scenes has plummeted, and one of the main ghost gun manufacturers has essentially gone out of business with this rule in effect. Does it give you optimism that a majority of the justices allowed the rule to take effect, that it's sort of been working, and now this is coming back to the court at a later date when it's very clear that this was needed and has been quite effective?
I don't know if it gives me optimism, because the 5-4 ruling that allowed the rule to stay in place was very much procedural, and it was not a case that had oral arguments and the like. And so it's unclear to me, when I think about the 5 versus the 4, if Roberts and Amy Coney Barrett will switch once it gets to the merits versus just the procedure of saying we'll allow this to stay. I hope they do. They should. They try to make ghost guns sound like really highly technical, but they're not. And so there's no reason why this should not be regulated under the Gun Control Act. But I really don't know which direction they'll take.
Okay, that is not comforting, but thank you. Appreciate the candor. We usually say whenever your fate is in the hands of John Roberts, you're probably screwed. At Slate, that's a bit of a motto, so fair enough. It's interesting hearing the conversation so far, environmental protections, gun control. It's interesting how much the court's term already maps onto some of the ambitions that we've seen in a potential second Trump term, especially as laid out in Project 2025. We know that Project 2025 has so many provisions about deregulating the environment, about nixing environmental protections left and right, and really abolishing the federal government's authority to protect the environment and protect citizens' right to a clean environment. The same is true of firearms, right? This is a key plank in Project 2025. Deregulation of firearms, total embrace of basically an unregulated market in guns. And another really, I think, alarming key plank of this plan here is the assault on LGBTQ people, which leads me to the next case that's very much on our radar. And Lene, I was wondering if you could talk us through United States versus Skermetti, because it seems like this is maybe the biggest trans rights case to come before the court ever, arguably. And it's one that is so relevant to the election that's happening in just a few weeks. And I was wondering if you could sort of talk us through both the case and the context in which it arises, this broader war on transgender existence.
Yeah, let's start with the context. I think any of us who, are paying attention to the conversation on the far right or Project 2025 are very aware that Christian nationalists, J.D. Vance, Trump have become obsessed with transgender young people. They talk about it all the time. They're like, that is their number one thing that they like to talk about and make up lies about. And so, of course, they're MAGA Supreme Court decided to jump right into the same fold. And I think it's very much in the same themes that we've been talking about, where the court is inserting itself in something that it knows absolutely nothing about. They're not experts on healthcare for transgender young people, but they're going to make themselves experts on healthcare for transgender young people this term.
Do you think they'll listen to the actual experts?
I really hope so, but I think I'm concerned. So here's why I'm concerned. We have seen this obsession grow very, very quickly. So if you look, there's actually a really revealing quote by one of the far-right architects of these attacks in the New York Times. In a 2019 article, one of these women said, we realized that we lost the marriage battle, and so we had to figure out what was next. So we threw a bunch of spaghetti at the wall to see what stuck. That was her quote to Jeremy Peters in the New York Times. And it's true, that's what they did. And they have now decided that transgender young people are that spaghetti that has stuck to the wall. And so we've seen over just a matter of 4 years, 24 states have outlawed gender-affirming care, healthcare for transgender young people, have inserted themselves and said parents are not allowed to make healthcare decisions for their children. Pediatricians are not allowed to make these healthcare decisions, could be jailed or sued for making healthcare decisions that align with the standards of care for young people. And the stakes here are incredibly high because these are states that I don't think we're going to win back anytime soon. So we now live in a country that is about half completely hostile to transgender young people. We're going to see people, and already have, moving to different states because they can't get the healthcare that they already have and need. So there's a lot at stake here. I'm hopeful that the Supreme Court will step in and say, this is ridiculous. Parents get to make healthcare decisions with their pediatrician for their child. John Roberts isn't the one who gets to do that. But the reason I'm concerned is that this should be a simple case, because there was a case in 2020 that was about transgender people, was, you could say, potentially before this, the most important transgender rights case in the Supreme Court. And in that case, the Supreme Court said it is impossible to discriminate against a person for being transgender without discriminating against that individual based on sex. If that is the case, then case closed. We're done here, right? And so the fact that they even decided they're going to insert themselves here makes me very concerned that they're not going to respect that statement. They're not going to respect that precedent. So the case here comes out of laws in Tennessee and Kentucky that have outlawed a whole range of healthcare for transgender young people. Specifically at issue in this case, because of who the plaintiffs are hormones and puberty blockers that folks might use to align their gender identity and their physical form. So what these states have said is that those medications are totally okay to use. They're safe, except if you're transgender. Everyone else is allowed to use them. So for me, I'm like, okay, that's literally just sex discrimination. I don't know how you can characterize that in any other way, because you're saying what are the genitals that this person has, and that's how I'm going to determine if this medication is appropriate for them. And that is not where the Supreme Court should be making those decisions. It's obviously where medical experts should be making those decisions. So if the court respects its precedent and says, you know what, this is sex discrimination, then the question is, does the state have a really good reason that they would want to put this law into effect? And is this the best way to accomplish that reason? And I think the answer is pretty clearly no, because in every other context, we let doctors and parents make these decisions. And here, they're really targeting transgender people in a way that is so obvious, and that's true across the country. So the question is, will the Supreme Court say, that's unconstitutional, that's sex discrimination, and strike down all of these laws and make it again safe to be a transgender young person across the country, or will they go in a different direction? And I'm concerned that, folks like Gorsuch and Roberts, who were on the right side in the 2020 case, are gonna say something like, well, young people are different, so we have more of an interest here, or not adhere to their standard that they set out in Bostock, and say we just need a rational basis and there's enough here, and try to distinguish from where they've been in the past. And I think it's a real risk that we face.
So just to make sure I understand how these laws operate, let's say parents walk into a pediatrician's office in Tennessee and they say, my child is undergoing precocious puberty. They're experiencing puberty too early before adolescence. They need puberty blockers. Totally legal for the doctor to prescribe that.
That's right.
But if parents walk in and say, my child identifies as transgender and needs puberty blockers to delay puberty for some time to deal with gender identity issues, that's criminal.
That's correct, which is why it seems like it should be an open and shut case, but obviously they don't think so because they've inserted themselves in it.
Right.
And I think what is deeply concerning is that this does align with the broader Project 2025 agenda, and it aligns with what we've seen from Republicans in Congress too. They have tried to attach bans on healthcare for young people to literally every bill over the last few years. You know, we've seen a funding bill for research at children's hospitals on rare diseases try to be stopped by putting a ban on this healthcare. So, like I said, they're obsessed with it. They're going to continue to try to stop parents from being able to get the medically necessary care that their children need. And this is one of the ways they're going to do it, but I don't think it's the only one.
So it sounds like what you're saying is if the Supreme Court upholds the bans in Scrimeti and Donald Trump wins re-election in November, this problem is becoming federalized and imposed on people in blue states as well.
Absolutely. And I think, you know, it is already very, very difficult to get this care. We held a roundtable with some providers of healthcare for trans youth a couple months ago, and the healthcare providers were saying they have a waiting list of 18 months to even talk to someone, because they already have patients coming from other states. It's very similar, obviously, to what we're seeing on reproductive rights, that these people who provide this care, that are the experts, are being overrun in the blue states already because they're having to serve the folks in places where this care is illegal. And the thing that I think is just the most infuriating about this case in particular is that the people that are suing are already on these medications. They're already getting this health care, and the Supreme Court is stepping in to say, you actually have to stop having this healthcare that you are currently on. And I just can't imagine the impact that would have on a young person and the kind of person who's trying to insert themselves in that way. It's this broader, you know, agenda of control and compliance and trying to tell every American how to live their lives that just syncs up perfectly with what they're doing post-ops.
Okay. Thank you. I mentioned the election, and our next and final, but certainly not least, panelist is going to talk us through the election, because I think, you know, so many of these cases, they aren't directly voting rights cases, they aren't election law cases, but the election could bear directly on everything that we're talking about today. And so, Jess, could you sort of talk us through the issues that have arisen or are likely to arise in terms of voting rights and election law as we get closer to November and this becomes a very active contest and people are at least trying to make their voices heard in it?
Yeah, absolutely. So starting with some context, when I think about this Supreme Court and the upcoming election, I think sort of two things are true. The first is that this court has been indisputably hostile to voting rights. We've seen that, you know, from Shelby gutting the VRA, in Brnovich, you know, a sort of further piling on during the pandemic, blocking courts from taking steps to make it possible for disabled voters and other voters to cast ballots during the pandemic. And at the same time, they have so far resisted the impulse to sort of join in efforts to overturn or seize power over election results. We saw that in 2020 when they sort of stayed out of cases, and we saw that in the independent state legislature case, Moore v. Harper, last year. So I sort of hold both of those things when I look at the issues that are likely to reach the court this fall. There are three that I want to highlight. One is an issue around late arriving mail ballots, which is coming up in Mississippi and Nevada, but could have broader implications. The second is this question of undated ballots in Pennsylvania that has been ping-ponging around the courts for years. And then finally, I'll return to sort of issues raised by that independent state legislature decision from last year. So first, with respect to late arriving mail ballots, this is an argument that the RNC has been making in cases in a couple of places in the country this year, sort of most prominently in Nevada and Mississippi. The argument is that when 18 states allow for ballots mailed on or before Election Day to be counted as long as they arrive at the election office within a few days of the election. This takes into account the fact of, mail is sometimes slow. You want to respect the voters who cast those ballots. The RNC is arguing that doing that violates federal laws saying that elections have to take place on election day. So far, this argument has been rejected everywhere, including in Mississippi, where Mississippi defended its law saying that you have to count these late arriving ballots. But just yesterday, an extremely conservative panel of the Fifth Circuit heard argument in this case. So it is possible that they will view this issue differently. And if they do, I think there's a good chance that this issue gets teed up for the Supreme Court at some point this fall. Even if they lose at the Fifth Circuit, I think it's possible that this issue stays relevant. And it matters because in Nevada, a key swing state for the presidential election, in Texas, where the Senate race could be closer than we expect, in California and Nevada, which may be decisive in House races, those are all places that under current law would count late arriving ballots and could be affected by this issue. So that's one issue that we're tracking that could find its way to the court this fall. The second thing I'll mention is this case around whether Pennsylvania has to count undated mail ballots. The rule at issue here is about a law in Pennsylvania that says you have to put a date on your absentee ballot. It still has to arrive at the election office before election day to be counted. So voting rights advocates have said this is a sort of small problem and you shouldn't disenfranchise somebody because they forgot to put the date on their ballot. This is a live issue in Pennsylvania state court right now, but it could come up to the Supreme Court related to the independent state legislature issues that were decided in Moore v. Harper. And in that case, there's kind of a theme on this panel of the Supreme Court sort of grabbing power or sort of holding power for itself. I think that's true in Moore v. Harper too. So in that case was primarily about whether state courts could constrain the actions of state legislatures with respect to federal elections. Going back to the sort of framework that I started with, the outcome at the Supreme Court was sort of positive from a democracy point of view. They said, no, state legislatures are subject to constraint by state courts, but we're going to hold the possibility that federal courts should review and intervene if state courts go beyond their typical scope of review. And the size of this loophole is kind of sort of unknown at this point in time, but there are cases percolating up that will raise this issue and sort of test the size of that loophole. One of them is out of Montana and was brought by the Consovoy firm, which has been very active on behalf of the RNC in this cycle. So these are three issues where you could imagine them coming to the Supreme Court in emergency postures later this fall in ways that would affect either kind of how voting happens in November or potentially even which ballots get counted.
So you are taking maybe a slightly less alarmed tone from some of our other panelists and also me. It seems like you think that there's a chance the court is not going to reach in and grasp at some of these kind of edge cases this cycle. Am I reading you right?
I think so, but but don't take it as optimism about the Supreme Court necessarily. So I think it's actually very hard to tee up an issue for the Supreme Court that would be outcome determinative for the election. We all are thinking about Bush v. Gore, but I think it's important to remember how unusual that set of circumstances was. The Electoral College came down to one state by an incredibly narrow margin, and there was a technical malfunction with the voting machines that made it hard to quickly discern the actual outcome. It is possible to imagine similar sets of circumstances. I mentioned Nevada is one of the states that counts late arriving mail ballots. If Nevada were the decisive state and they hadn't resolved this issue ahead of the election and there was an potentially outcome determinative number of late arriving mail ballots, you could imagine. I don't know that I'm optimistic that in that situation, the Supreme Court would decline to reach in and decide. And if you view that issue through a sort of voting rights frame, there's reason, to be skeptical of what they might do, setting aside their kind of partisan interests here. But I think that whether they will actually have the opportunity to decide the election feels like still a pretty low, even in a very close election, which I think, we all know we're headed towards, still feels relatively low likelihood.
Okay, we'll round that up to optimism. Before we turn to questions, I just wanted to briefly sort of ask all of the panelists. So many of you have mentioned shenanigans in the lower courts. You mentioned the Fifth. Well, I think we've all mentioned the Fifth Circuit. It haunts us to varying degrees. I was wondering, especially for those who aren't closely following what's happening in the lower courts, and particularly places like Texas, if any of our panelists wanted to sort of talk about what you're seeing among especially Trump-appointed judges in some of these places that might have single judge divisions, that might be very tilted to the right, and how they're issuing these extreme decisions, and especially what influence or impact that is having on the Supreme Court as they maybe confront issues that they don't necessarily want to confront yet, or as they try to shape their docket in a way that sort of matches their agenda. And I'm opening it to anybody.
On the influence piece, let me just, give you a little bit of context, which is the Supreme Court decides less than 100 cases a year. The appellate courts decide, I think, about 12 or 13,000. It's a lot. So, we usually only pay attention to judicial nominations when it's at the Supreme Court level. We need to change that.
Right. And the court has been basically quiet quitting. We were down to about 60 cases last term, which is an historic low.
That's right. And that's because they're getting the outcome they want from the lower courts, because they were able to install these Trump judges. And I was saying earlier to the panelists that my first job in Washington was working on judicial nominations. And at the time, Democrats didn't care about judges at all. And the right wing very much did. There has been an asymmetry for a very long time. I think that's changing to some extent because of Dobbs and because of the craziness and the hijinks we've seen in the Supreme Court. But if we are people who care about democracy and care about justice, we need to care about the appellate courts, and we need to talk about them way, 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 way more, because they are both shaping the Supreme Court's docket, because that's how things get up to the Supreme Court. And if some crazy Trump panel decides something a certain way, then the Supreme Court can say, oh, well, there's a circuit split, so now I have to take this. And they just queue these cases up for them in a way that allows them to grab for them. But also just because most cases are decided by those judges, and they are just as bad as what we're seeing in the headlines around the Supreme Court. And I think the only difference, which I hope our next panel will talk about, is they actually have some ethics requirements. So that's a good thing that maybe we should work on here. But other than that, they're just as unbound by precedent and the rule of law as we're seeing at the Supreme Court.
Can I say something? Please. A lot of the administrative cases a piece of which I was talking about, cases where agencies' rules on a variety of subjects are called into question. Regulated parties can choose their judges. In Texas and in Louisiana, there are districts that only have one federal judge, so they can know that if they challenge that rule in those districts, they can know who their judge will be. And the judges themselves have declined an invitation to change that practice, right? And you can know that those judges, when they get a rule that they perceive as too ambitious, they will slap a nationwide injunction on that rule. And all pieces of it. These are complicated documents. They don't just have one basis. But slap an injunction on all of them. Then those rules go up to the Fifth Circuit, famously conservative, also outdoing the Supreme Court in terms of hostility to the administrative state. And then the Solicitor General of the United States, who represents the United States in the Supreme Court, has a choice to make. Do I let a really important rule go because the Fifth Circuit struck it down and the Supreme Court is also difficult? Or do I appeal it? And they've chosen to appeal, which I think is the right result. But the Fifth Circuit's boldness, egged on by judges chosen precisely for that purpose by the litigants, The Supreme Court, it means that the Solicitor General brings cases to the Supreme Court that maybe, if this weren't true, they might choose to not to. They don't want to be in the Supreme Court, but they're forced to be in the Supreme Court a lot because of the boldness of these courts. And it interacts with the so-called shadow docket, the emergency docket, insofar as just as the lower courts have a great appetite for enjoining rules before they've really taken a close look at the merits of those rules, the Supreme Court has a great appetite for deciding these cases on an emergency basis. And I think we'll see the court using its shadow docket as a standard way of reviewing administrative agencies' decisions, which also really, really takes a toll on expertise because they have to look at that case really quickly, decide whether to take it, decide whether to enjoin without any of the nuances that the agencies really trade in.
Oh, I just wanted to pick up on something you said about the extremism of some of the lower courts sometimes making the Supreme Court take cases that it doesn't necessarily want to take, because something we've seen in gun violence prevention is that the case that I was telling you about with ghost guns is more about administrative law and whether or not the president had the power to do an executive order. But in the Second Amendment context, the last case that the court heard, the Rahimi case, which involved the federal prohibition on individuals subject to domestic violence restraining orders having a firearm, that case came up because a lower court said that that was unconstitutional under the Bruin standard, and that was so extreme that it forced the Supreme Court to actually moderate the rule that they came out with in Bruin, which said that when you're analyzing a Second Amendment case, the test is whether or not a current modern law comports with history and the text of the Second Amendment. And I don't think that the Supreme Court necessarily would have wanted to do what it had to do in Rahimi, but because that case was so extreme, because as an outsider, it seems like Justice Roberts, for example, wants to at least appear to be reasonable. And so when you have a rule saying that because of this Bruin test, that now if you are under a domestic violence restraining order, you have a constitutional right to a firearm, it sort of forced their hand. So I think there's an interesting dynamic there where sometimes these lower courts maybe get out in front of their skis a little bit and go so far that when you're dealing with cases, at least in our context, where the Bruin case was sort of very broad and the court didn't really say what that test looked like. And I think the lower courts, some of them got a little too excited and forced them to moderate. And I don't think they necessarily would have wanted that at all.
And I think they definitely didn't want to do it decide that case around that particular man, because Rahimi was basically the opposite of the impact plaintiff that you would want. If you're choosing who are you going to make this decision about, he was the worst case scenario. And I think if you were on the side of, wanting to blow open our gun laws even further, he's not who you would have picked as your poster child.
Kelly, do you have anything to add there? Sorry, not Kelly. Kelly just gave us a wonderful addition. Jess, do you have anything you'd like to add?
Yeah, I mean, I think the Fifth Circuit, the late arriving ballots issue that I was describing earlier, why is the RNC litigating this issue in Mississippi in 2024? It's because Mississippi is in the Fifth Circuit. They were able to tee this issue up for this extremely conservative panel. And so I think that's just another example of how folks are kind of forum shopping their way through these lower courts. And TBD what will happen in that particular case, but it's almost an unusual example in the election context of an opportunity to forum shop.
Right. We have time for just a few questions. If you're in the room, I think we'll do first. If you want to raise your hand. And we have a person with a microphone. And if you have a particular panelist you want to direct your question toward, please do.
Good morning. My name is Andy. I work at the Embassy of Belgium following domestic policy. So you talked about the lower courts and the composition of the lower courts. So from my perspective, a lot starts at the Senate, which needs to approve the judicial nominations. I was wondering if you have any insight as to how many nominations are currently being blocked or stalled or just in any way boycotted in the Senate. Thank you.
Well, thankfully, we right now Democrats control the Senate, and so and whether you think this is a good idea or not, we now have gotten down to a 50 vote threshold to confirm these judges, which is how we got some of these terrible folks on the Supreme Court. But that's neither here nor there. We get to confirm as many judges as we want with Democrats in the Senate. And I have to say the Biden-Harris administration has done a much better job than previous Democratic administrations of recognizing that and caring about it. Again, I think in part that's because we've all been awoken to how terrible these court decisions can be. And in the past, we kind of assumed the courts were on our side, on the side of progress. And that so clearly isn't the case now. So they've been rocket docketing these judges through as fast as possible. And the only thing that stands in the way, obviously, is timing, floor time in the Senate. But they haven't been doing much else. So they've had some floor time to work with. And then obviously the upcoming election. And I am not optimistic that we hold the Senate for the next time around. And that might mean, for example, that Harris doesn't get to confirm anyone. It is possible that Republicans, if they control the Senate, would say, we're just not confirming anyone. In fact, I have heard from some Republicans on the Senate side that they're not even going to confirm cabinet officials. They're just going to say no. So they certainly wouldn't confirm lifetime appointees. So I think there's a real open question about if Kamala Harris is the next president, whether she gets any judicial nominees through an extreme MAGA Republican Senate.
Another issue that's been arising is that Republican senators are blocking nominees from their home states, and Democrats are still generally honoring blue slips for district court judges, which means that a Republican can effectively block a nominee from their state for a district court. In theory, Democrats are no longer honoring blue slips for appeals court judges, but it doesn't always work out that way. And right now, for instance, Senator Tom Tillis of North Carolina is blocking one of Biden's wonderful nominees to the Fourth Circuit, Ryan Park, who's currently the North Carolina Solicitor General, who would be, I think, just a superb jurist. Just sort of out of spite, Republican senators are attempting to block him because he wasn't approved by them, and he's not going to be a MAGA judge, presumably. So that's sort of I think, one of the dynamics that's hindering a more rapid confirmation in the Senate. Other questions in the room?
We have an online question.
Please.
Okay, so this question's from Giovanna Kinsel, who asks, how can we improve the speed in which courts address and modernize processes in respect to regulation of topics such as ghost gun law regulations and the systems they compromise and or affect?
So I think this is a question about congressional fixes. Lisa, I was actually curious if you think that this is a fruitful thing for Democrats to pursue, especially. Do you think that there can be congressional fixes to some of these admin law decisions?
Yes. Some
and
of
they'll
them
stick.
Well, first things first. One thing I didn't mention, which I think looms large, is the Supreme Court at the same time decided a case on the statute of limitations, the deadline for filing actions against the government, including actions under our Federal Administrative Procedure Act, which is the primary statute governing review by courts of agency decisions. And they said you can sue if you do it within 6 years of the time you're first injured. And what that means is you can form a corporation and decide, I'm hurt by this particular EPA rule that was enacted 40 years ago, and so I'm going to sue to challenge it. Do you see that? That it's dated not from the date of the rule, but from the date one is first injured. And there are lots of stories out there about law firms kind of going through lists of rules that they'll challenge, partly enabled by this change to the statute of limitations. The reason I say that is just that I think that would be an easy fix, and that would take away some of the sting of changing the interpretive rules long after the statutes have been passed. Another thing that Congress could do is try to figure out a way to, the court's ruling in the case overruling Chevron deference was statutory. They didn't decide it constitutionally. Then the question is, what will they do next? So I'm not making any promises, but on their own terms, it was statutory. It was an interpretation of the Administrative Procedure Act, which I just mentioned. And that's a statute passed by Congress. Congress can change that statute. So Congress could decide on either a global change like that disavows the kind of interpretive approach the Supreme Court took, or they could do it agency by agency, statute by statute. But this is something that, at least according to the four corners of the Supreme Court's opinion in that case, is statutory. It belongs with Congress. They can change it. The but is that the court's opinion, the majority's opinion, was just filled with constitutionally inflected language. Like, this is just what courts do. It's always been thus, right? Our entire history, except for Chevron, has been one where courts interpret statutes. And when they say things like that, it makes me worry what they do with a statute that actually, changed what the court had done. And a lot of these other issues are, in theory, Congress can respond even to the more case-by-case statutory judgments. But I guess I would say, and I'd love it if Congress were more active, but the question is the Supreme Court the one who should be telling Congress what its priorities should be and how to draft legislation?
Time for maybe one more question.
Hi, Mike McInerney from Roll Call. I was just wondering, do you have an outlook for what cases you're looking at on the long conference list, or, an outlook for, the cases that are currently on the shadow docket?
Panelists, what's keeping you up at night?
There are 10 emergency applications in environmental cases, many of them consolidated. So I think the last count I checked, it was 3 major EPA rules, one on climate change, 2 on climate change, one on methane, one on carbon dioxide from power plants, and then one on air toxic emissions from power plants. And, they've been hanging on to those. And I do think, as I said, the day is coming when the Supreme Court will be the primary court for administrative law challenges that are challenged by billionaires.
I'll just say briefly, and I think you know this, of course, but, the Second Amendment decision from last term was so sort of cryptic in how it did or did not alter the previous Second Amendment decision, which was utterly unworkable and almost indecipherable. And there are now a bunch more Second Amendment cases piling up on the doorstep of the court, including a major one out of the Fourth Circuit on assault weapons bans, whether states here in Maryland, but there are a bunch of others, can outlaw assault weapons. And then there are just so many other issues about whether people convicted of felonies can have firearms if it's nonviolent, and just on from there. So I think there's a very good chance that the court will take at least one more Second Amendment case this term.
And I would be remiss if I don't say, when we were talking about ghost guns and bump stocks in those cases too, because they're administrative law cases, there are a lot of states that have active bans that are coming at them not from an administrative perspective, but more from a straightforward Second Amendment perspective. And those cases, in those states are good law, and there are more coming, but also I would hate if the court were to ever consider that, like, on the merits. This particular court, I should say.
Yeah. Okay, thank you so much to our panelists. Thank you to the audience. That's everything that we have for you. And I'm now going to turn it over to Devon Ombres, who is the Senior Director of Courts and Legal Policy, who will be introducing our next panel, which is on reforms and what Congress can do about the mess that you just heard. Thank you.
So good afternoon. Thank you all for sticking around for a second panel on court reforms. I'm Devon Ombres. I'm the Senior Director for Courts and Legal Policy at CAP. Please allow me to introduce our amazing panel. First, Minnie Timaranju, President and CEO of Reproductive Freedom for All. Next, Lena Zworenstein, the Senior Director of the Fair Courts Program at the Leadership Conference on Civil and Human Rights. And rounding out our panel, Alex Aronson, founder and president of Court Accountability. Okay, is this on? Okay. I want to do a little bit of level setting first before we jump right into the nuts and bolts of what court reform could look like, what is necessary, how the courts are. You just heard a good bit about how the courts are failing the American people, so we want to talk about what we need to do to fix the courts. And having just heard that panel, I think it's a little bit clear why the court is presently riding an all-time low for a couple of years now approval rating in the country. They've dipped down below 40%. I think they're at about 42% right now. But conversely, the American people recognize what the court is doing, and we are looking at now about 70% of Americans across the political spectrum. That means 70% of Democrats, 70% of Republicans, 70% of independents that believe judges have too much power, and only about 30% believe that judges are now fair and impartial checks on the other branches of government. Public support for reforms is growing. A Fox News poll, Fox News, from July found that 78% of Americans approve of 18-year Supreme Court term limits. Likewise, 70% of Americans support a binding code of ethics, including 6 in 10 Republicans. So think about that. Even, we are at critical mass for actual movement and getting our legislators to reassert their authority and say, this court, you may be the Supreme Court, but we are the first co-equal branch of government. And so given this state of play, I'd like to just turn over to our panelists for brief opening statements on, how do we tie ethics and term limits together? What other reforms are needed? What does this look like? And if I can just go straight down the line, that would be fantastic.
Thanks so much, Devon. I'm Alex Aronson with Court Accountability. First, thanks so much to you and CAP and Third Way for co-hosting this event. I think the conversation we just heard about the court's docket this term, the damage it's already done, this majority that has really taken the Constitution, by its reins and advanced this very hard right agenda, reflects a dangerous development in our constitutional politics and our constitutional law. The aggrandizement of power by this court to sort of become the ultimate arbiter of not only law, but of policy and all the rules that we're living under in our society, which has our very sort of delicate constitutional balance deeply out of kilter. And I think these questions about power and legitimacy really underscore the moment we're living in. And some of the polling that Devon mentioned, reflects the extent to which the American people are starting to see how out of kilter things are. There's a great quote from Casey. I'm sorry to bring out my phone, but Steve Laddick had a really good post this morning on his blog First Monday about these questions of judicial legitimacy and the court's legitimacy. And of course, the court does not have, as it has recognized, the power of the purse that Congress wields or the power of the sword that the executive branch does. Its power really rests on its legitimacy and public faith in what it's doing. And the court has acknowledged this. They said its legitimacy depends on making legally principled decisions under circumstances in which their principled character is sufficiently plausible to be accepted by the nation. And I think what, those numbers, this increasing realization, this growing support for reform reflects is that faith, that the belief in the principled nature of these rulings is not there. And that it's no accident, right? These majority justices did not organically take their positions on the court. And we're starting to understand this now as investigative reporting that Ben articulated in his introductory remarks, has helped the American people understand. The power that the court is wielding is the product of a calculated campaign by right-wing special interests over at least the past 50 years, really starting with Brown versus Board of Education, the backlash to racial integration, growing in power through the 70s with the dissemination of the Powell Memo and the embrace by the American business and corporate community. I see Nan Aaron in the audience really saw this, early on, the effort to wield this insulated and unaccountable judicial power against the people. And then, of course, the development and fostering of an electoral base around the religious right and the aim of ending Roe versus Wade, which of course has been accomplished now. And so increasingly, we've just got a court that is out of kilter with the American people, and it really puts pressure on Congress, I think, now as the primary representative of the American people, and the branch that is being most disempowered by this agenda to step up and address some of these reforms that we'll get into in this panel.
Well, thank you, Devon, and thank you, Alex. And thank you so much to CAP, Third Way, and Court Accountability for hosting this conversation. I want to thank many of you in the audience who have been at this for a very long time, probably watching online, and those maybe not watching, but who have really been bringing the importance of the courts, the importance of changing and improving this institution. People have really been at the forefront of this for quite some time, but I'm excited about all of the attention it has been recently getting. So, as mentioned, I'm Lena Zworenstein. I'm with the Leadership Conference, and we are a coalition of more than 240 member organizations that are committed to the civil and human rights of all of us, because we want to create a thriving, multiracial democracy, and that's why for decades we have been paying attention in close partnership with our members and other partners to the courts, because fundamentally we want to make sure our courts work for all of us. One thing that I want to mention from the last panel, when Ben opened, he talked about in his introduction a bit more about like the question of who do we entrust with justice. And so one thing that we have been working on for decades in partnership with many of you has been who is on our courts. For that more than 70-year history we have had, we have wanted to, and again, worked in partnership to advocate for judges and justices who we know serve for decades, and removing them is incredibly hard. The only way to do so is through the impeachment process. And we want to make sure that these judges and justices are fair-minded, ethical, possess a demonstrated commitment to civil and human rights, and that they are actually reflective of all of our communities. And that means demographic diversity. That means coming from a number of rich legal backgrounds, voting rights experience, employment law experience, working on behalf of voter rights, and so on and so forth. And I appreciated the question also asked earlier about, the types of judges that are pending. This administration has been quite great at nominating so many wonderful judges who fit that criteria that we have long been pushing for. So far, there have been 213 lifetime confirmations. There are 17 right now currently pending on the Senate calendar that we need to get through. A lot of them have the type of experience we need to see on the bench, really fighting for things like religious freedom, fighting for things and advocating long for a lot of protections of civil rights, voting rights, the opportunity for educational equity, and so much more. And we have a lot of more folks pending. So it's a real need there. And I want to just underscore this because I think that this is one of the shortest term ways to change our court. We're talking about some of the other fixes and reforms, but this is something that, as mentioned earlier, is getting a lot more attention, but still needs a lot more energy around it, because fundamentally putting these folks and making sure that they are the right folks in these seats matters tremendously. But for a long time, we've also been tracking the institution writ large and the ways in which it is being rigged against all of us. Again, we want to make sure that the court is working for all of us. When the Leadership Conference's previous interim CEO and longtime CEO before that, Wade Henderson, he testified in front of the Presidential Commission on the Supreme Court and different reforms. He really presented two main themes by which we are always looking at any types of reforms or changes to the institution itself. One, what will strengthen our democracy? What will make it more inclusive, where people can participate, see themselves in the process? And two, to really center on the communities that are most deeply impacted and quite honestly have historically been harmed. Those are the communities that many of our incredible members are representing, and because we do want to be making sure that the court serves everybody. So the Supreme Court has long needed a code. I want to thank everybody for the pressure, that investigative reporting and so on, because the court did put out a code of conduct. It's unfortunate it was so weak. There's no enforcement mechanism, and we still need continued oversight on what that means. But we also know that there needs to be a congressional response, and have been long urging that along with our folks in the coalition. So we do need to have a code that is not just written or in theory. It needs to be in reality and be able to put into practice, and they're thus enforceable. But more is needed. And I think recently the Judicial Conference announced some other rules that really show that Congress needs to act. We can't create exceptions for certain justices who may be getting entertained by these wealthy billionaires, et cetera. So, a lot of the reforms specific that we're going to talk about, ethics, term limits, gift bans, preventing harassment and discrimination in the judiciary, which judicial employees right now, they're not protected. It's really important that we protect them, and more, I think, is really important as it really girds the whole entire idea of our democracy.
Minnie?
Thank you. It's so nice to be with all of you today and so many partners. We are proud members of the Leadership Conference. We are proud partners of Court of Accountability and CAP. Our good friends at CAP, who we work with in our Federal Reproductive Rights Coalition work, and Third Way, really great partners there as well. I believe I am here because of the obvious, which is that reproductive freedom and reproductive rights have been the thing that's blown up this conversation in this country and have really galvanized grassroots activation around the courts. For many years, my organization, Reproductive Freedom for All, probably known better to many of you, formerly as NARAL Pro-Choice America, has been active in judicial nominations, active in lobbying on the courts. But many of us in the movement had not taken a position on major court reform issues like ethics, expansion, term limits, the host of solutions that we're going to dig into today. And, I think it's because, like many of us in the progressive movement, we've always been nervous that those strategies could also be used against us. Meanwhile, those strategies were being used against us, not so subtly. And then we woke up one day with a 50-plus year freedom taken away from us. And constituents across the country of many of our orgs saying, how the hell did this happen when we are the political majority in this country, right? 8 out of 10 Americans, including Republicans and independents, are with us on having a legal right to abortion. And yet the court just stripped this away. And if anyone thought, okay, well, that's it, it stopped, we just have to look to the next big case that really shook the country, which was the Americans for Hippocratic Medicine, the HM case, commonly known as the medication abortion case or the mifepristone case, in which you had one Trump-appointed judicial activist, a judge, who was able to completely upend and create turmoil for the FDA and for abortion providers in states where voters had already said, I want these rights protected, right? So it kind of really upended the whole, BS, being polite, BS, around states' rights, right? We're going to kick this to the states, and then we're going to stay out of it. No, you're not. They're not staying out of it. They're trying to upend the whole system by going through the courts. They were able to override the will of the people by going through the courts. So now it's been a wake-up call for our movement that it's time for us to be much more engaged, and we have members, activists, the American people on our side. So I think for us, the next step is working with so many of you to figure out how do we take this surge of public opinion in the direction of reproductive freedom, and how do we educate in the plainest terms voters and the American people and Congress that court reform is reproductive freedom, right? You don't have reproductive freedom without court reform or a host of the other civil rights that we work on with our friends at Leadership Conference and that are hand in glove, like voting rights, et cetera.
Thank you all so much. Lena, I want to piggyback on something you said about the Judicial Conference changing rules and creating exceptions. On Monday, for those of you who are not as deep into the weeds on court watching as some of us are, the Judicial Conference amended one of their disclosure rules to make it clear that when a judge receives so-called hospitality from a billionaire benefactor, if that hospitality is provided through a shell company that billionaire or their family owns, then that is not reportable under the are we calling it the Code of Ethics still? The statement of ethics that they put out this year. And our friends at Center for Responsible Ethics in Washington, CREW, have taken to calling this the Thomas exception, which I think is more than appropriate. So, I mean, Alex, at this point, are the courts not just thumbing their noses at the American people and Congress by saying rules don't actually apply to judges? What are we looking at as far as ethics and how to actually get them in line with the rest of government?
Yeah, I think that's a really good read, Devon. They're thumbing their noses at the American people. So self-assured in their own immunity that they feel like they can get away with this. And it's not just their own code of ethics that they are sort of writing out of effectiveness. It's federal laws that the American people passed through Congress and were signed by the president. These are post-Watergate reforms, the Ethics in Government Act. And they've, done a very nifty little, statutory interpretation within the Judicial Conference guidelines that creates this massive loophole. Interestingly, after the stories started coming out about Justice Thomas last April, they scurried and made a clarification to those rules that actually would have required these types of disclosures. And now, just 1 year later, they've retreated and allowed those exemptions to continue. And frankly, this is a pattern that has gone on for decades beyond what we know about Justice Thomas's own engagement with these very ideological, very interest-driven billionaires who bring many of these cases, particularly the administrative cases that Professor Heiserling was talking about, to the court. We know from Justice Scalia's death at a secret fraternal order gun club at a ranch in Texas. After he passed away, a whole bunch of his friends and associates came out of the woodwork to talk about hunting trips that he had taken with them. And he had figured out this loophole decades ago where he would get himself invited by a law school, and then he would organize a privately hosted retreat at a fancy lodge to go hunting. And he did this, to our count, it was at least 86 times, probably many more than that. He went to the NRA. The NRA hosted him, in Germany, where they awarded him a silver pistol while the Heller case was pending. The place was full of gun rights activists. One of them came out of the woodwork and discussed how Justice Scalia had been discussing with him the procedural advancement of that case while the case was pending. So, I think the pushback we're starting to see from the right-wing legal movement that has organized to defend them, saying that these criticisms of the court are an attack on its independence and legitimacy. They're very much designed to protect this corrupt scheme that they have orchestrated for years. And so certainly what I think we can take away from maneuvers like what we see from the Judicial Conference this week is that this judiciary, certainly under the supervision of Chief Justice Roberts, cannot be trusted to police itself. It is not going to do the right thing. And so then it falls to Congress and the executive branch, frankly, to make sure we have laws in place that police the conduct that we know is taking place, and then make sure we have an executive branch that enforces the laws as written. And it implicates exactly the same rule of law questions, the same accountability questions as we've seen around former President Trump and the prosecutions there.
Yeah, I think that's right, Alex. And if members of Congress were being feted on these junkets, the electorate would be raising holy hell about it. But because they're justices who are supposedly beyond reproach and in their ivory tower, it goes completely under the radar. And frankly, they are lawyers who are very good at finding loopholes in the law. Lena, I want to turn to you briefly. CAP supports both term limits and ethics reform, and in a recent report we put out, we Inspector General, which could go over the entirety of Article 3. How do you see these two components coming together, ethics and term limits, in a more fulsome push for reform? And what does effective enforcement look like?
Yeah, almost anything feels like it's going to be more effective than what we have now. But one thing I want to maybe tying this in the previous question together is just to talk about just how entrenched it is, which is why I think it is so vital that Congress take the authority that it has to do something about this. Alex was describing a lot of these trips that people take, but when President Biden announced, his support for term limits and a binding code of conduct, which we agree with, CAP agrees with, I think at least in the concepts of it for sure, it was something that well, caught a lot of attention. And then, as you mentioned, Justice Kagan, Justice Jackson, and others have just commented like, yeah, this might be a good idea, and we could have like a panel of judges talk about it or whatnot. But at the same time, in a recent ProPublica article, there was the revelation that the wife of Justice Clarence Thomas, Ginny Thomas, emails the head of one of the main litigating groups that brings some of the most egregious anti-civil rights litigation in front of our courts, our lower courts, and our Supreme Court, First Liberty, where the president and CEO was touting to donors and bragging about the fact that he got this email from Ginny Thomas thanking him on behalf of all these federal judges for their efforts to block, to counter any types of reforms, which just on the basis to have our highest court be held to no ethical standard is ridiculous. Like, it is absolutely impossible. Like you mentioned, anyone in Congress caught on any trips like this or being held to these ethical standards, I think would be laughed out and have been and prosecuted and more. And I think it just shows a bit how entrenched this is. And when Fifth Circuit Judge James Ho also then decides to write an op-ed saying, hey, we've got this, that I think tells you everything you need to know about the folks that are trying to say that they are ethical, that they've got this. They're trying to protect, I think, some of this, what they might be perceived as, not necessarily immunity per se, although that's a very loaded term right now, but they don't want to have this level of accountability, and that speaks, I think, volumes. Now, the ways in which I do think Congress has previously, passed legislation. I mean, Congress has this authority. They set the number of justices at the Supreme Court. They create the number and where our lower courts are. They have in the past said, hey, there's this thing where the U.S. Constitution says judges say that, or the Constitution says that judges serve, quote unquote, during good behavior, which we've interpreted to be lifetime. But hey, we're not going to kick you out of office, but we're creating this thing called senior status, which I think your report does a really great job of articulating how they've been able to do that. That is something that a lot of these term limit bills have done, and say, hey, we're going to say, we're not kicking you out of office. What we're doing is shifting the types of cases that you might be hearing or exactly which court you're sitting on, which to me seems very, very reasonable. But between that and having something where there is something like what Senator Blumenthal's bills does, which is, and you mentioned like an inspector general, having someone like that or a council or councils of folks, ideally this would not necessarily be someone that the Chief Justice alone picks. I'll just note that, talk about a little bit more of the who is being held accountable is important. And I think that is something that I'm certainly looking at when I look at a lot of the different bills, like who are we entrusting with some of these measures? I think that there are a lot of really fantastic options that are out there. But the two things I want to sort of mention on enforcement, or at least in that whole the apparatus of having somebody who can provide meaningful advice as well as investigation into these things. I think that Supreme Court justices right now, they kind of confer with their friends about what they think they maybe should do if they do, and things like recusal, when they should be actually hearing a case or not. It would be really nice if there was perhaps a neutral counsel that everybody goes to that can be trusted by everybody who can say, not a good look, and that there is more public transparency about why those decisions are made. And then that other piece, that investigation, that enforcement, I think it's going to be really critical to have somebody who is, not necessarily Chief Justice Roberts himself as being the one who is making these determinations, but something like an inspector general, which is something that is very common in our government to have to be able to provide some sort of enforcement. But that really are just some of the measures I think we need to take. There's a lot more that I would love to see strengthen our institutions so that we can trust them more to do not just the right thing, but the ethical things too, and that we can really trust that their decisions are based on fact and law, not who their friends are, who's financially well off, and who has that power and who's ingratiated themselves.
Thanks, Lena. Minnie, I want to give you a chance to chime in on this ethics issue as well, but I think it ties in very well to the question I was going to ask you regarding our good friend Matthew Kacsmaryk in the Western District of Texas, who decided that he, a well-known, prior to being on the bench, a well-known anti-abortion crusader. He implemented the nationwide ban on mifepristone. Interestingly, the Fifth Circuit, or some of these judges, seem to be shying away from nationwide injunctions because when he just struck down the universal background check rule, he only applied it to 4 states: Texas, Louisiana, Mississippi, and Missouri. So I just want to get a sense of, when we're looking at ethics, how do you feel that Congress and these ethical boards should be looking at not only Supreme Court justices, but the lower court justices? And how should Congress be thinking about ways to prevent these litigants from hand-selecting not just their judges, and this is a much more complex question that we can all talk about, but the circuits that these cases are brought in, because the Fifth Circuit is going to do what the Fifth Circuit is going to do.
That was a lot. I will do my
Apologies.
best. I am the least qualified on this panel to dig into the solutions, but I can kind of talk about what I think some of the political challenges are and some of the bills that we're tracking and following. I just want to gently push back, and this is probably going to get me in trouble, but that not all of our friends in Congress are beyond reproach in these same areas. When you said junkets, I was like, that's a thing. That's a thing members of Congress do. And when we talk about approval ratings for the courts, I mean, Congress's approval ratings are pretty terrible consistently as well, right? So I think, and then you couple that with the reticence of some of our most senior, institutional leaders in the Senate who are really great on these issues, but are really hesitant to take action because they are institutionalists, right? They're nervous about court reform, much like we're hearing a lot of nervousness, and I know that's not the topic today, but it's on my brain, about the filibuster, right? I mean, these are folks in the Senate who are on our side, but have a lot of anxiety about major reforms. So I think Congress is in a bit of a bind. I think it's incumbent on us to build a political movement that puts them on the spot and says, hey, this is the only fix court reform is the fix we're going to demand, but we have to create political momentum, because I do not think naturally this will happen just because it should, right? Going back to Matthew Kacsmaryk, lots of conversations on the Hill about how do we prevent Matthew Kacsmaryk? How do we prevent more Matthew Kacsmaryks? And currently it's pretty hard, to prevent it. But a couple of things I'll say about Kacsmaryk, in addition to his background as an anti-abortion extremist, he is also colluding effectively with organizations that are being created and filed in his jurisdiction to bring these cases. So in the Miffy Pristone case, AHM is, many people don't realize this, but no real doctors or abortion providers in AHM. I think the biggest medical provider in AHM was a dentist. It's a bunch of right-wing anti-abortion orgs that filed an organization, claimed to be medical, and did it in his district to get in his court. So there's a larger, set of questions here about who gets on the court, but who's qualified, who has standing. And remember, ultimately, what made the Supreme Court kick this back was standing, right? But the fact that it even made it to the Supreme Court is just crazy. For the lower courts, which you specifically asked me about, there's a couple of legislative fixes we're tracking. There's an End Judge Shopping Act, requires random case assignment for cases with national implications. There's Stop Judge Shopping Act, which is the first one is Senator Schumer, the second one is Senator Hirono, gives the U.S. District Court jurisdiction over cases that require federal law enforcement. And there is a Fair Courts Act, Senator Wyden, and in the House, Representative Ross, 3-judge panel for cases with national implications. So I think these are all ones we're tracking and generally supportive of as a coalition. I think ultimately, though, I'm going to be really boring and say these are all really important things that we should try to address and fix through Congress. But there's a larger political problem here, which is judicial nominations. And this is where I agree with Lena. We need to really rapidly fill these spots. And I want to praise the Biden administration and Leader Schumer for doing a very fast push to get a lot of qualified judges in. But the Trump administration's record and how quickly they were able to stack the courts with really, really terrible extremists who under any other admin wouldn't have even passed muster, right? I mean, whether it's Kacsmaryk or, Amy Coney Barrett, what are we doing? Like, we are going to be in this bind for a long time because of the incredible damage to the courts that Trump was able to do in a very short 4 years. And that should be, I know this is C3, so I'm going to be careful, should be an issue we're talking to voters about right now, and many of us are.
That's fair. You brought a lot that makes me want to comment about standing issues and how concrete injury is a requirement under statute to bring laws. But I think we all saw in 303 Creative, the Colorado bakery case, the person who brought that case had just started their business and at some point in time could have been asked by a gay couple to make a cake. And if they refused, the couple could have complained to the Colorado Civil Rights Board, which could have then taken action. So we're 4 steps away from finding a concrete injury, yet the Supreme Court granted standing in that case, seemingly because it wanted to. So I don't know how Congress pushes back when the Supreme Court is acting in explicit derogation of statutes that are on the books of their own case law and common law requiring these standing issues and concrete injury to be addressed. But, I want to talk, but to that end, I think one of the things that folks have been talking about is one of the more complicated reforms is jurisdiction stripping. Ways to prevent the Supreme Court from getting to these laws and being able to actually take away Americans' rights or prevent public agencies from protecting them against special interests and the powerful. And I think most prominently in recent terms, and by that I mean the last month, Leader Schumer introduced the No Kings Act, which is addressing the Trump immunity case, prohibiting the Supreme Court from taking up any questions on the constitutionality of it, and prohibiting judicial, but more minutely, more, I think, surgically, in the Inflation Reduction Act a couple years ago, Congress said that there shall be no judicial review for the drug price negotiation, drugs that are selected for that. They said no judicial review whatsoever, which means that the agency and Congress can work hand in hand and figure out what is best for the American people to save them money. That, of course, is now being challenged. But I want to get your take on the broad sweeping implications of jurisdiction stripping versus the more surgical nature of it and how it plays into how we should be thinking about court reform.
Awesome. Thanks, Devon. There's so much in this conversation to unpack. I think before I dive into jurisdiction stripping and the No Kings Act, I'll note that the litigant that brought the wedding website case that Devon was just discussing was the same special interest dark money group, the First Liberty Institute that Lena mentioned, is working with Clarence Thomas's wife to fight back against court reform and is in private calling Justice Kagan treasonous. And so, I think all of this, reflects the extent to which this right-wing apparatus, which, over the years has, increasingly controlled judicial selection from the right, is actually using the courts as a legislature, is contriving these cases, cooking up doctrines, funding think tanks and professorships in the academy to bring these cases to judges that they know will welcome these new ideas and turn them into law. And they've got this court, as Minnie pointed out, the unfortunately timed passing of a hero to many of us, all of us, I assume, Ruth Bader Ginsburg, and her replacement by one of Leonard Leo, the Federalist Society, dark money bagman's favored judges, Amy Coney Barrett, entrenched this movement in the judicial power for the foreseeable future. Some studies have calculated that if things were to remain static and we were to wait this out, the shift in the balance of power on the court would not move back until 2065. And meanwhile, they are, incrementally and increasingly rapidly advancing a right-wing anti-democratic agenda that is deeply unpopular and completely at odds with the will of the American people. And I think it's foolhardy also to think of them as simply controlling the levers of power within the courts. The same dark money faction is behind Project 2025. It's all the same right-wing billionaire interests and theocratic Christian nationalist interests that are pushing this movement. and they are heavily present in Congress, behind the Republican Party in Congress, and they are one of the reasons that we cannot rely on Congress to advance these interests. It's why the Senate has been such a obstacle to progress. Things like the filibuster. It's incredible to see Vice President Harris on the campaign trail, saying that she wants to get rid of the filibuster, which is in many ways a real relic of the slave era, right? That it didn't get created during slavery, but has been used by slaveholding interests and by the opponents of civil rights progress to stop progress. In the very same way, the courts and the power that it is agglomerating to itself is standing in the way of democratic progress, which goes to these questions of jurisdiction stripping and the balance of constitutional power. In some ways, yes, Devon, it's a complicated advancement, but in some other ways, it's fairly simple. I mean, the exceptions clause of Article 3 of the Constitution makes clear that the court's appellate jurisdiction, which comprises 99% of its docket, is subject to Congress's exceptions and regulations. Now, the scope of Congress's power, pretty clearly, that the textualist power is quite clear, but this is sort of, as some have described it, the nuclear question in constitutional law, and it's never really been resolved. And so, now that we're in this moment where our democracy and, all of our values are being choked off and we are facing a real authoritarian threat, the question is, how should we seek to push that power? How should Congress seek to wield it? And I think that the No Kings Act is a really promising development. It's got, Leader Schumer introduced it. It basically says the court got it wrong in the immunity decision and takes away the court's jurisdiction from resolving claims of immunity brought by former presidents. It leaves in place, through the District of Columbia Circuit, an ability to challenge the constitutionality of the law. But this is the type of movement we need to start seeing, in that movement groups, which I think are increasingly seeing this threat as the obstacle to all their progress, need to start demanding of representatives in Congress.
I have so many more questions for each of you, and we're unfortunately running out of a little bit of time. So I'm going to combine this one for Lena and Minnie if I could. And it's building off of what Alex just said. And it's, Lena, it's something you touched on in your remarks, is, this judicial branch is now so poorly esteemed that it is harming American democracy more so than I think a lot of other issues. What does a further diminished illegitimate court, how does that play into the broader body politic? What does that mean for our freedoms in the future? And how do these reforms that we're talking about help staunch the bleeding? How can we, rebuild some legitimacy? And what does a legitimate court actually mean?
So, it's a huge question. And I just want to say, fundamentally, so many of our institutions were not actually built to serve all of us. That includes women, people of color, people who don't have wealth. And over time, in the very spirit of the ideals of our country, we have tried to make it more perfect, more inclusive, much more of a thriving democracy. And that has meant change through things like constitutional amendment, through statute, and so much more. And so, when I think about the ways in which, as you mentioned how important it is that the judiciary actually have public confidence in order to have any sort of legitimacy, because that's the only way it is able to actually thrive or actually survive a bit in our democracy. It is really important, I think, to do a few things. One is to actually be not just talking about this, but doing something about this. I do think the public conversation did put a lot of pressure on the Supreme Court to create a code of conduct, albeit a terrible one that is not enforceable. But that is, I think, really, really critical. And when we in Congress put even more of a critical eye on this, to do more oversight, et cetera, I do think it creates more pressure. Now, I want the Congress to still do something. There are a lot of statutes that can be passed, and those are things that I do think over time can help people feel more confident that the decisions that court, those judges at the lower court levels, judges like Matthew Kacsmaryk, which many of us opposed before he received his lifetime appointment because he was known to be so anti-civil and human rights, him along with, many of the 234 previous appointments by the previous administration. But we do want to make sure that the institution itself, through ethics, that they can be actually held accountable, like we all should be held accountable, actually works. So I do think it takes a lot of congressional action. And I do think, to your point about the popularity about term limits, it doesn't mean that the justices are suddenly going to lose their job, but that's a lot of power to hold. For a lot longer to hold. I know many of us know the folks over at the Academy of Arts and Sciences who've done a lot of great work picking up on what the Presidential Commission on the Supreme Court did, have talked just about the longevity of justices staying on the court and just the median number of years they've been on the court. Historically, I think it's been about 18.6, if I remember right, years that they've been on the court, whereas now it's like almost 10 years beyond that, at least 26 years. And so these are trends that we're seeing that I think are really important for us to make sure we are addressing as a way and a mechanism to make sure people don't feel like folks who can be bought off without any sort of accountability are actually ruling in everybody's interest and provide equal justice. But the other thing, and I want to really applaud, there are a number of scholars in this space, but particularly I know Professor Maya Sen from Harvard has done a lot of work about how to build more confidence in our courts, and a lot of that is through diversity. So through the diversity of the judges and justices that are being appointed, not only does that build public confidence because people in our communities can see somebody like them perhaps has been the one who's issued this decision, but it also improves judicial decision making. And I say that, as somebody who's going to constantly talk about these confirmations, but those decisions aren't just in the decisions that they're issuing on the cases, but I think it goes into very much decisions that they are making in their chambers. Are they going to hear a case? Are they going to recuse themselves? And if they know that they have more eyes on them from their peers, I do think this is a much bigger culture change, but I do think that is a continued important aspect when we're talking about creating more confidence in our courts. And I know we're very much focused on the federal courts right now, but I think that some of these measures have been adopted by a number of our states. These are not somehow new or radical for the United States of America, but rather it is really, I think, incumbent on folks to say, it's time, this is too much. And historically, this has had something where this has not been a partisan issue. There have been people on all sides of all aisles who have really supported the idea of term limits, of ethics, of banning gifts, things like that, which I think we really need to take more seriously.
Thanks for bringing up the states, and I'll just make two very quick points. More and more Americans are getting to vote, are consciously aware of the fact that they get to vote on their state Supreme Court. So as that consciousness increases, especially in critical states like Wisconsin, where, we're going to need that state to be highly engaged for many reasons this cycle, you have Americans who are like, wait a minute, why don't I have some say over the courts? They're paying more attention, and they're more engaged in what is happening, and they're feeling an urgency to reform courts through the democratic process in their states. So how does that tie all together? I mean, if we get a federal trifecta and Congress does not move forward on these reforms, on some of these reforms, doesn't show meaningful movement, you're going to have an electorate that's going to really question why. And it's going to really damage the reputation of Democrats in Congress. And I think that's a really important message for us to convey across the board. You have a mandate. Look at all the states where folks have come to show up on our issues that are tied to the courts. Look at all the states where folks are expecting action when it comes to courts. And now we need you to take action. If they decide not to, or they get into too much internal debate about institutionalism, we're going to have a really hard time bringing them back.
That's fair. So I want to get a little bit into the nuts and bolts of what reforms could look like. And we've been thinking about, and if we could just try and keep it under 90 seconds, because I'd love to get to some questions from the audience. In the terms of term limits, in terms of ethics enforcement, in terms of transparency, gift bans, all of these things, what does a broad and actually useful package, to get to Minnie's point, let's get down to nuts and bolts and not talk about internal debates. What is actually useful to bring the court to heel? And do you want to jump off?
I mean, I want to hear from the experts, but I would say ethics, number one. It feels like it has the most consensus, and it should be the easiest to do. So let's do it fast and show the American people that we're serious. And then I think, term limits. I mean, to me, I think judge shopping is important, yes. I think those are harder things to do when you have the courts stacked. So I think addressing the makeup of the courts, and then very, very rapidly continuing to do the great progress, including diversity of background and ideology and geography of the appointments.
So I'm with Minnie. I think the ethics stuff is no-brainer, kind of low-hanging fruit. There's some really obvious stuff. I mean, even some of the really excellent comprehensive ethics packages don't go so far as to ban some of these gifts. And Jamie Raskin and AOC in the House have introduced a really wonderful, very straightforward gift ban that just keeps these justices from taking these types of gifts beyond disclosure. Term limits, there's two sort of competing approaches being advanced right now, one that is prospective and one that's retroactive. I think we would tend to favor a retroactive one, given the long tenure of some of the justices that are on the court majority now, and frankly, given the illegitimacy with which they are wielding their power. So those are going to be things to resolve. I do also think that we can't be thinking about court reform, as sort of Minnie has suggested, it's important not to do in a silo of court reform. It's deeply connected to all of our issues. So as we're trying to codify abortion protections, as we're trying to restore voting rights protections, there's a court component in all of that. Maybe it's a jurisdiction limitation. Some of it is just a question of what is Congress going to do when and if the court strikes this stuff down? Because they will, or they very likely may.
We need to at least invite them to do it, though, and we need to do something. Make them do it. Yeah, exactly. And I do think that there is, so much constitutional authority for Congress to act. So I don't want to minimize that, but with the judges and justices that we have, maybe they are not going to get there and say it's constitutional, but I think we at least need to continue to push that conversation. So I think folks have really articulated, a binding code of ethics, and I think that looks like a few things that some of it I've already mentioned, that there is this enforcement mechanism, something that's, an investigative entity, maybe an entity that can also provide, counsel, as I've mentioned before. There needs to be more public disclosure over things like recusal, and there needs to be more transparency so we have a better idea of what that looks like. And we do need to make sure our judges are, and everybody in the judiciary is protected if they are ever discriminated against or there's harassment, or in the case of what we've seen in, unfortunately, the District of Alaska, sexual misconduct. There is a really great bill that Senator Hirono and Congressman Johnson have put out, the Judicial Accountability Act previously. That's, I think, a really core component to making sure our judiciary does work for everybody, and that those basic civil rights protections are also applied to the judicial staff there. But I do think, you mentioned Congressman Raskin's really great gift ban bill. I think that's a really important component. And I want to continue to invite the conversation about, I've mentioned, Congress has the authority to set the number of seats on our Supreme Court, and having continued conversation, I think, around that continues to be important. But there are some of these things where I don't want to say it all has to be done. I would love to create some sort of big, here is the ultimate package. And I think I'm continuing to think about it, but it is also, we need to do something. And I think ethics is the very bare minimum, but getting to term limits and forcing these conversations to banning gifts, I think are really, really critical. More short-term to intermediate steps we must take.
And just putting the gift ban into context, members of Congress are prohibited from taking a gift worth more than $50 at a time, more than $250 per year from any number of sources. Meanwhile, our good friend, Justice Samuel Alito, was feted by, let me get this name right, German Princess Gloria von Thurn und Taxis in her 500-room palace for a music event that she put on and was given $900 concert tickets by her. He did actually disclose this, but Princess von Thurn und Taxis is also deeply connected to the far-right movement in Europe, and may or may not have. We'll not get into that. But the point is, gifts like this should not be accessible to Supreme Court justices. So I'd like to open up questions for the audience and online. If anybody has any questions, we have one of our staff with a microphone.
Thank you. I'm Jay. I'm a practicing attorney. Why doesn't the advocate organizations go use the examples that the right has used? For example, why doesn't California pass a similar bill on gun control that Texas passed against abortions? Why doesn't someone bring a case in Mississippi comparable to the Hobby Lobby incident where they say their religious belief says that there's no life until birth? Why doesn't a Columbia football team prey on the football team?
So there's been some attempts at this, and I think from a political standpoint, I think Governor Newsom's actually been out there talking about this quite a bit. The challenge is our side is too, we're too fair-minded. In the best of ways, and a lot of folks in these legislatures aren't really in favor of that strategy. They want to actually get things done. And in the states where we have Democratic supermajorities, they're there because they're doing pragmatic things. That being said, I think it's an interesting strategy. I know Democratic leaders in some of the blue states are exploring it. And more importantly, Democratic AGs are probably the most activist in terms of thinking about these strategies and how to challenge the right. And are frankly the most progressive, at least from our perspective. Democratic DAGA, the Democratic Attorneys General Association, is the only party committee that requires candidates to be pro-reproductive freedom for an endorsement by the association. So I have a lot of confidence in AGs. I think they're really, really leading the way. I think legislatures are kind of tough.
A couple other thoughts. One is, I think, largely speaking, progressives, liberals, the liberal legal advocacy community is on the defensive. They have the courts. They've secured them. And so those strategies, I think, would be less likely to succeed. I don't think the principles that the courts have, accepted in the context of, say, SB 8 in Texas, the abortion bounty in Texas, would stand in the, if it were to be deployed, because I don't think that it's being sustained by virtue of principle, but rather by virtue of outcome orientation. We also, frankly, lack the sort of centralized infrastructure that Leonard Leo and the Federalist Society have been able to build over the decades, using the money of mostly fossil fuel industry and other regulated industry money that has a huge self-financial interest in the investment in this infrastructure, which isn't to say that there isn't any resources on our side, but they don't there's no centralized sort of cabal that sets an agenda. We've got groups like ours that work together and work in coalition and sort of live the values of democracy that we're trying to espouse and work towards. And so it doesn't lend itself as well to this type of coordinated strategic approach.
But there's tons of power in that, to be clear, and I think that's how our power is really sort of derived. But I think one thing and one reason why I think what we're talking about now is so important is that, to the point Alex is making, so many of these courts have been absolutely stacked, and the litigation has been brought in this way in response to the progress that the civil rights movement created, and Brown versus Board of Education and so much more. And that is a huge reason why so many of the states in the South, and where those vacancies where we have a lot more to be filled in places where we heard on the first panel more about the types of cases that are coming through Judge Kaczmarek and the Fifth Circuit, why that is so important. So a state like Mississippi, their legislature may not be doing something, but it's really important for us to gird our institutions that we have some control over to make sure that they are more pro-democracy, more fair-minded, and at least being held to some sort of ethical standard. But then you have someone like Judge James Ho saying, no thanks. But it's really important that we continue to put that pressure on, I think.
Next up.
Good afternoon. Hamil Vaidya, professor at Georgetown. Thanks for the session. CAP was kind to provide water and coffee before. I'm thinking after both of these awesome panels, we want to pivot to an open bar right afterward. My question focuses on hopefully a little bit more real, I think a more realistic aspect of accountability, which is testifying in front of Congress and the Senate Judiciary in particular. And just for kicks, I reread the letters from Chief Justice Roberts as well as Justice Alito declining respectfully or not respectfully to testify. And the thrust of both of those letters was essentially giving Congress the finger. And so my question is, if we can't get all of the reforms that you all have notably pointed out, because I don't think the question is a Democratic majority, frankly. I think it's 60 in the Senate. And so we've got a higher threshold. If we can't get those reforms, can we at least move the needle regarding getting them to come and collaborate and to testify in front of the committee, at least to get the dialogue going? I would appreciate your thoughts on that.
Why are y'all looking at me? If I had a way to get the Supreme Court justices to come and testify, I absolutely would. I don't think that is a bad idea in the least. I think Congress should flex their muscles, and Congress is so reticent to do that in any facet that it's really disturbing. Because I'm not quite sure if I had that answer, I'd give it to you.
There's been a historic reluctance, as Devon notes, to do real oversight of the judiciary. But Congress has oversight muscles here. They know how to use them with respect to the executive branch. We've seen that throughout our history. Certainly, we saw it during Trump. The House subpoenaed, Mazars to get Trump's tax records. That case went up to the Supreme Court, and John Roberts wrote an opinion that really reinforced the importance of congressional oversight power as broad and indispensable, in his words, in pursuit of its legislative functioning. And that's the root of this oversight power. If Congress is to pass laws that affect the country, it needs to understand what's going on, and it needs to be able to conduct oversight. In the face of, very clear violations of federal law, federal recusal law, federal disclosure law by the Supreme Court justices, we should have seen a stronger move from Congress and the Senate Judiciary Committee in particular to put pressure on the justices. When Chair Durbin did invite Chief Justice Roberts to testify around the initial disclosures around the scandals, the Thomas and Alito scandals, he declined to testify, and he asserted that the separation of powers protected the court, the judicial independence protected them. But that really reads out the whole notion of checks and balances in our Constitution. It's totally at odds with that principle in Mazars. There's no reason, really, that the broad and indispensable oversight power should apply with any less force to the courts than it should to the executive branch. And so Congress really needs to start exercising those muscles if we have a chance to get to the bottom of this.
And I will say the Senate Judiciary Committee, through Chair Durbin, also Senator Whitehouse's really, I think, incredible efforts have been trying to write more letters, make more sort of accountability, whether it's to the judicial conference, to the justices themselves. And I do think continued invitations at a minimum, and us knowing, hey, they're not going to be there, but bringing in experts to really go through this is also, I think, important. I also want to, thank, under Senator Wyden's leadership, the Senate Finance Committee has also, maybe that's not where we all think, but when it comes to things like these gifts or how people are hiding, or are they writing off some of these gifts, and maybe violating the tax laws, I think those are really important oversight. Opportunity doesn't feel like the right word, but it is really important for us to really have much more visibility, oversight in those ways. And so this is a muscle I think we need to be flexing a lot more, and I think we can continue to be creative about it. I mean, we know that, the Senate funds the judiciary. There are, I think, important mechanisms that, where Congress does have very significant control and impact and accountability, and it needs to make sure that it is really flexing all of those muscles.
And the Supreme Court justices come to Congress when they need appropriations. Yeah. They do. They show up in hearings.
And the Supreme Court justices, the ones that are responsible for these most egregious decisions, came to Congress, lied about their positions on abortion and Roe v. Wade, and were confirmed with less than 60. So American people aren't buying the 60 anymore. You better fix it. If you get the majority, you need to fix it. Rules reform has to extend to all of our freedoms. The American people will not stand for this anymore. It's getting to the point where you can hide behind the filibuster, you can hide behind institutionalism, but there is going to be a growing demand Because otherwise, to Alex's point, we're not waiting till 2065. I mean, I'll be dead. I mean, I'm not letting my children live under this crooked regime. So we have to create an urgency. I believe the American people are going to demand it. I think that's why you heard the vice president talking about rules reform. I don't think anyone had that on their, in their predictions. But they're feeling the demand. They're feeling demand when they go out and to talk to the American people about why we can't fix the crisis created by the Dobbs decision.
You mentioned the lies that the Supreme Court justices told to Congress regarding Roe and other things.
Outrageous.
But let's go back to Ben's opening statement 2 hours ago. Thank you all for sitting here for this long. When John Roberts went in front of the Supreme Court and said no man is above the law, and that includes presidents. And then he wrote an opinion not 4 months ago that said, just kidding, presidents have the same immunity that kings do. So obviously reforms are very big. Thank you all to everybody who has come. And everybody who is online. I think it is critically important that we continue discussing what reforms look like, what reforms are needed, and how we get there, because as our amazing panelists have said, we don't want our children and grandchildren living under a regime where Supreme Court justices are bought off by the highest bidder. So thank you all for being here. Thank you to our amazing panel. Thank you to Third Way and Court Accountability. Thank you to Leadership Conference and Reproductive Freedom for All. Thank you, guys.